Welcome back to Krishna's Laurels. Today we'll be discussing Article 30 and Article 32. So Article 30 talks about right, rights of minorities to establish and administer educational institution, whereas Article 32 talks about right to constitutional remedies. So, what is right to constitutional remedies in a sense? When someone breaches your fundamental right, you can approach Supreme Court or High Court for remedies that is mentioned in Article 32. So in Article 32 safeguards your fundamental rights and gives you remedies. Coming to Article 30, rights of minorities to establish and administer educational institution. Hopefully you know that we have few educational institutions governed under some trust, minority trust and endowments. So under Article 30 they have right to establish, like how we have some missionary schools or say madrasas, gurukuls. These are made under those rights are given under Article 30. Article 30 grants the following rights to minorities, whether religious or linguistic. It can be anything. We have saw the meaning in Article 29. What is linguistic minorities? So, whether it is religious or linguistic minorities, they have given rights under Article 30 to what? That all minorities shall have right to establish and administer educational institution of their choice. So we have missionary schools, for say example. The compensation amount fixed by the state for the compulsory acquisition of any property of a minority educational institution shall not restrict or abrogate the right guaranteed to them. So what they mean is, if a state occupy their land, a particular minority's land on which they have made their institution, educational institution, or else they thought to make an institution in future. If that particular land have been acquired by state, then the state should give a fixed compensation amount to them, or else give them a new land, allocate them a new land to establish their educational institution. This provision was added by 44th Amendment Act in 1978 to protect the rights of minority in the regard. The act deleted the right to property as a fundamental right, that is Article 31. If you know, just drop in comment box what in Article 19 we have right to property before, and it have been removed under which Amendment Act, and what Article 19 which subclause it was. Just drop it in comment box. This third point, what have been said in Article 30 is, in granting aid, the state shall not discriminate any educational institution managed by a minority. It shouldn't be only preferring Muslims, or it shouldn't be only preferring minorities, that is Christians. So what the C point is saying, that discrimination should not be made against any particular minority managed educational institution. It shouldn't be said that it is managed by Muslims, so we'll not be investing in it, or we are not giving any financial aid. There should be no particular discrimination. So this Article 30 protects right of only minorities and not to the all citizens. How we saw in Article 29, where they have mentioned that it doesn't matter even if a majority claims the right to safeguard their culture or language, they have the right under Article 29. But in Article 30, it is specifically mentioned that it is only for minorities, whether it is religious or linguistic. However, the term minority has not been defined anywhere in the Constitution. In Constitution, there is no particular definition of the minorities. The right under Article 30 also includes the right of minority to impact education to its children in its own language. If you are in South India, say like Telangana, in Telangana, missionary school is running. If they want, they can like make it all Telugu medium, everything in Telugu, because it's their language. So they have right to do that. Minority educational institutions are of three types. Institutions that seek recognition as well as aid from the state. First one is that the education is seeking aid, that is financial help, as well as recognition from the state. State is government. The second one is institution that seeks only recognition from the state and not aid. For say, Saint Teresa, something like that, Saint Anne's. Institution that neither seek recognition nor aid from the government. The other one is like wholly private. They are running themselves. They are not seeking any aid. They are not seeking any recognition from the government. The institution of first and second type are subject to the regulatory power of the state with regard to the syllabus, prescriptions, academic standards, discipline, sanitation, employment of teaching staff, and so on. So even if you have studied in your school, you might see that recognized from Telangana state or Telangana state government or Telangana state board. If you are recognized or if you are funded by any government, then you should compulsory follow their rules and regulation. You should have a particular syllabus prescribed by them. You should have academic standard, in a sense school must be this much big, there must be proper teaching employees, like staff should be well educated and qualified, there should be discipline, there should be sanitation, in a sense proper toilets, water facilities, cleanliness and all. These things should be followed if you are first one, that is funded by government or recognized by government. Second one is only recognized by the government. So these two institutions will be following all rules and regulations given by the state. The institution of third type are free to administer their affairs but subject to operation of general laws. General laws are like our general ones: labor laws, industrial laws, tax laws, contract law, economic regulation, and so on. So the third type is like completely private. There is no aid from government. There is no government restriction, and they can administer, like maintain their school affairs as they want. But the general laws should not be violated. These are all the general laws prescribed under our constitution. So here, in a judgment delivered in the Secretary of Malkanna Syrian Catholic College case 2007, the Supreme Court has summarized what Supreme Court have said, that the general principle relating to establishment and administration of minority education system in the following way. So this is a summary of what in this judgment. What is a Secretary of Malankara Syrian Catholic College case 2007, Supreme Court have given a judgment, and this is the summary. So the right of minorities in the Supreme Court judgment, they have mentioned that the right of minorities to establish and administer the educational institution of their own choice comprises of which rights? Number one right is to choose its governing body, in whom the founder of an institution have faith and confidence to conduct and manage the affairs of the institution. In essence, first right of them is its governing body. The trust itself decides who will be the management, who will be the one who will be founder of the institution, who will be managing the day-to-day affairs of the institution. Second one is to appoint the teaching staff, also the non-teaching staff. So here, to take action if there is a dereliction of duty on the part of its employees. So this thing, how to appoint a teaching staff, how to appoint a non-teaching staff, what will be the eligibility criteria, and if someone doesn't work properly, or if he's not what say performing their duties properly, uh, how they will be reacting will also be uh, decided by them. Third, right is to admit the eligible student of their choice and to set up reasonable fee and the structure. If you know that Senpai or Sentence, these colleges are not registered under those. If you just passed out of intermediate and you want to get into BCom, BBA, you need because they're autonomous colleges, autonomous, and they are governed by themselves. They take what you say. exams in their own university. They have their own set of patterns, and you have know that what is their eligibility criteria is different from other government regulated colleges. This is what it is talking about: to use its properties and assets for the benefits of the institution. uh, their properties under the trust can be used for the benefit of the institution. This is also the right. And the second one is the right to confer on minority under Article 30 is only to ensure quality with the majority and not to intend to place the minorities in more advantageous position, vice versa in the majority. So why this right Article 30 have inserted is to ensure the equality with the majority. So many people do say that minority is oppressed. To get that equality, Article 30 have been inserted. It is not that they are favoring them, or they are showing some more uh, relief, or they are giving more advantage to minorities. It is not like that. It is to create equality between majority and minority. There is no reverse discrimination in favor of minorities. So it doesn't mean if you are favoring minorities, you will be discriminating majorities. There is no kind of discrimination between majorities and minorities, and there should be equality, which is the motive of Article 30. The general laws of land relating to the national interest, national security, social welfare, public order, morality, health, sanitation, taxation, etc., applicable to the all, will be equally applied to minority institution as well. These laws, which are general laws, will be applied to the minority institutions as well. The general laws can be paying of taxes, maintaining sanity, more morality in the society, maintaining the public order, seeing the social welfare. These are kind of like general laws applicable to everyone, whether it's minority institution or the state-run institution. The third right is the right to establish and administer the educational institution is not absolute, nor does it include the right to ma-administer. So the third point is saying that the right to establish or to administer a particular educational institution is not absolute. It's not your compulsory right to. You can't say that under Article 30 I have right to establish an educational institute as I'm minority. I'm Christian. I want to establish an educational institution. So it is not possible because it is not absolute, not does you it doesn't even have right to administer. It is not an absolute right. There can be regulatory measures as well. Right, sometimes even we saw in other fundamental rights that where they say it's not an absolute right and there will be reasonable restrictions. Let's say our right to speech, they say you can you can speak, you can give your opinions, you can express, but there again they say we have reasonable restrictions. Same here, we have right under Article 30 to establish educational institution, but this right is not absolute because they need to even take care of the regulatory measures. For what? For ensuring the educational character and standards and maintaining the academic excellence. If we give an absolute right to establish educational institution, then every third or fourth person will be saying that I am establishing educational institution, I am establishing school. To maintain the quality and to maintain the academic excellence, they have mentioned some regulatory measures. There can be checks on administration as necessary to ensure the administration is efficient and sound, so as to serve the academic needs of the institution. They will check that administration should be good, efficient, and sound. It should be capable enough to run a particular educational institution. Regulations made by state concerning generally the welfare of students, teachers, regulated lay down eligibility criteria, qualification, appointment, as also condition of service of employers. Here they are saying regulations are made by state to see the or to concerning about the students' welfare, or to regulate welfare of the students as well as teachers, and they regulate the eligibility. Like they have said, B.Ed is compulsory. From now on, B.Ed will be compulsory even for teachers who are teaching in schools, primary schools. So here they are saying that these regulations are implemented concerning about the welfare of the teachers as well as students. They can regulate the eligibility criteria of who should be recruited as a teacher, what should be the qualification, what will be the condition of service of employee. That can be both of the teaching staff as well as of the non-teaching staff. The regulations to prevent exploitation or oppression of an employees, and regulation prescribing syllabus, curriculum of study fall under this category. Under this category, they are seeing that employees, in a sense, teachers should not be oppressed or exploited. Oppression in a sense, what we say, doing bad with them or like exploiting them in a sense, giving mere salaries, no proper maintenance and all. It shouldn't be like that. And if under government, it is compulsory that PF should be deducted. PF, health benefits, and other benefits given to every employee, even including teachers, should be given. Such regulation do not in any matter interfere with the right under Article 31. So these regulations are not interfering with their rights, but they're ensuring that the quality education should be given to children, and teachers, the employees, should not be exploited. Subject to the eligibility condition, qualification prescribed by the state being met, the unaided monetary educational institution will have freedom to appoint teacher lecturers by adopting any rational procedure of selection. So here what they are saying is eligibility condition, qualification is being prescribed by the state, but even unaided minority educational will follow that, but still they'll appoint teachers and lecturers, appoint like adopting their own method how to like recruit a particular teacher or particular recruiter. The process will be decided by themselves. Extension by aid of state does not alter the nature and character of the minority educational institution. First point they are saying is, if state even aid them, give them some financial help, still it will not change the nature or character of the minority educational institution. There will be no influence of state. The condition can be imposed by the state to ensure the proper utilization of the aid. So it will not interfere with the educational institution's character or nature, but it can like impose some restrictions just to ensure that whatever financial help state have given is utilized properly, and without, however, diluting or abrogating the right under Article 30. Without affecting Article 30 and its rights, government can ensure that the whatever funds it is giving should be properly utilized. Now coming to Article 32. What Article 32 talks about is constitutional remedies, right to constitutional remedies. Mere declaration of fundamental right in constitution is meaningless. So when constitution was made, at that time they have decided we have given rights to the citizens, but what about if their rights are breached? There will be no use of fundamental rights if there is no protection given to the citizens. If the fundamental rights are breached, they must have right to go to any court or particular person to get the remedy. So here they are saying that mere declaration of fundamental right is meaningless and useless, worthless, without providing an effective machinery for their enforcement. And if they are avoided or violated, there must be some protection given, or like there must be someone who is regulating that okay, fundamental rights are ensured, enforced, and there is no violations made. So hence in Article 32 confers that right to remedies for enforcement of fundamental rights of an aggrieved citizen. So a person like me, say my fundamental right have been breached, I am aggrieved, in a sense I am victim, so I have remedy now. So I have remedy under Article 32, and I can approach any court and say that this have been happened to me, my fundamental right have been breached. So at that time under Article 32, I'll be granted with a relief. In other words, right to get fundamental right protected in is in itself a fundamental right. So right to get a fundamental rights protected, in a sense, if my right is protected if so my right is breached, then I have right to protect it, and this is also my fundamental right itself. To protect my fundamental right, it is also a fundamental right. Hopefully you're not getting confused. Just read this sentence again. Right to get the fundamental rights protected is in itself a fundamental right. This makes the fundamental right real, because just saying that okay, you have so and so fundamental rights doesn't make sense until and unless it is protected. That is why Dr. Ambedkar called Article 32 as the most important article of the constitution, an article without which the constitution would be nullity, because nothing would have been coming in effect. Even if your fundamental right breach, you don't know where to go, what to do, because there is no protection given. That doesn't make any sense. It is the very soul of the constitution and very heart of it. So it is saying that article 32 is very important article in the constitution. It is the soul and heart of the constitution. The Supreme Court has ruled that Article 32 is a basic feature of the Constitution. Hence, it cannot be abrogated or taken away even by the amendment to the Constitution. If you know, in preamble, we say we had a hopefully, if you know, in Keshav Nand Bharti cases and all landmark cases, they came. The only thing came was, can fundamental right be amended? Can constitution be amended? So the question where they gave an answer is that every part of constitution can be amended, in a sense changed, except basic structure, that is basic things like fundament of like what preamble and as well as Article 32. They have said these are the basic features and these can't be changed. It contains following four provisions. The right to move. So under Article 32, we have four provisions. First provision is right to move the Supreme Court by appropriate proceedings for the enforcement of a fundamental right is guaranteed. Say, if you want to enforce your fundamental right, you can move to Supreme Court by an appropriate proceeding. What is the proceeding? That is filing of writ petition. Writ petition. Okay. The Supreme Court shall have power to issue directions or orders or writs for the enforcement of any fundamental rights. So, Supreme Court is having a power to issue directions to so and so state, because our fundamental rights are guaranteed towards state. State can't violate our fundamental rights. So, Supreme Court is having power to issue directions saying do this, do that, do it right, like that, or order or writ. They can even issue writs, that is kind of judgment, what we say. We will be filing writ and they'll be issuing writ. So under this, under order direction of writ, the fundamental right will be enforced. The writs issued may include these are the writs. This is habeas corpus, mandamus, prohibition, certiorari, and quo warranto. The parliament can be empowered any other court to issue directions, orders, and writ of all kinds. So Parliament has power to empower, to give power to any of courts to issue direction, orders, and writs of all kinds. However, this can be done without prejudice to the above powers conferred on the Supreme Court. So, however, it can be done without prejudice to Supreme Court, because above we have seen Supreme Court has power for judicial, what you say, constitutional remedies, and even High Court has that right under Article 226. So under this clause 6, Parliament can empower any other court, means other than High Court and Supreme Court, because these two already have rights. High Court have right under Article 226, that is 226, to hear matters relating to fundamental rights, whereas Supreme Court has under Article 32. The right to move to Supreme Court shall not be suspended except as otherwise provided by the Constitution. So every person has right to move to the Supreme Court, but that right can be suspended according to the provision mentioned in the Constitution. Thus, the Constitution provides that the President can suspend right to move any court for enforcement of fundamental right during the national emergency. So we know, right, during national emergency, some of, like, not some of, mostly our fundamental rights are suspended, they will not be in effect, and we even can't move to Supreme Court stating that my fundamental right is not in effect. I can't, like, my fundamental right have been breached, saying that you can't approach Supreme Court because during emergency our fundamental rights are suspended. That is mentioned in Article 359, National Emergency. It is that clear the Supreme Court has been constituted as the defender and guarantor of the fundamental right of the citizens. So it is clear that Supreme Court under Article 32 is the protector, defender of our fundamental rights. It has been vested with the original and wide powers of that purpose. So Supreme Court have been granted original powers and wide powers to protect our fundamental rights under Article 32. Original because an aggrieved citizen can directly go to Supreme Court, not necessary by way of appeal. Because in other cases, uh, if we need to go to Supreme Court, first we need to start with basics, district court, magistrate, then to High Court, then again appeal to Supreme Court. But in this case, under Article 32, we can directly approach Supreme Court. Why? Because its power is not restricted to issuing of orders or direction, but also the writs of all kinds. We have five kinds of writs we'll be seeing on later. Here, Supreme Court is having power to issue order, give directions, and also to issue different kinds of, like, all kinds of writs. The purpose of Article 32 is to provide a guaranteed, effective, and inexpensive and a summary remedy for the protection of fundamental rights. Article 32 has been provided to give expeditious, inexpensive, and fast remedy. In a sense, it will be cost effective. In a sense, it will not be expensive. It will be fast. It will not be time consuming. It will be effective, and a summary remedy for the protection of the fundamental rights. Only the fundamental rights guaranteed by the Constitution can be enforced under Article 32, and not any other right like non-fundamental constitutional rights. So only the fundamental rights are guaranteed under Article 32. The violation of fundamental right is a sine qua non for the exercise of the right conferred by the Article 32. So here, if they are saying what is sine qua non means, it will be impossible to applicable. Without Article 32, protecting fundamental right would have been impossible, or which something which can't be performed. So Article 32 is very essential to protect our fundamental right. This is what it is saying. In other words, Supreme Court under Article 32 cannot determine a question that does not involve fundamental rights. So Article 32 is wholly and solely made for fundamental rights protection. Article 32 can be invoked simply to determine the constitutionality of an executive offer or a legislature unless it is directly infringing any fundamental rights. So you can even invoke Article 32 to whether, if say something, any law have been passed, any act have been passed in Parliament, and you're opposing it, you're saying it's not constitutional. At that time, even you can invoke Article 32. In case of enforcement of fundamental rights, the jurisdiction of the Supreme Court is original but not exclusive. What do you mean by original but not exclusive? Because we have even High Court here under Article 32. Sorry, under Article 26, 226, 226. So we can even approach High Court as well as we can even approach Supreme Court. Here, Supreme Court is original because we can directly go to Supreme Court, but it is not exclusive. If you want to file a writ petition, it is not that you should only go to Supreme Court. You even have an option. You can approach High Court under Article 226. The vested original powers in the High Court to issue direction, order, writs of all kinds, enforcement of the fundamental rights. So same as Supreme Court, High Court even have rights to issue directions, give orders, to give writs of all kinds, and to enforce the fundamental rights. To enforce fundamental rights, High Court have the same powers what we have given to the Supreme Court. So here, this is the reason we are saying that Supreme Court is original but not exclusive. It means the fundamental right of a citizens violated, the aggrieved party can move to option either to the Supreme Court or to the High Court. Here they are saying if my fundamental right, for example, my fundamental right have been what you say breached, violated, then I have right to directly go to Supreme Court under Article 32 or to go to High Court under Article 226. It's my option. Since the right guaranteed by Article 32, the right to move to Supreme Court where the fundamental right is infringed is in itself a fundamental right. The availability of alternative remedy is no bar to relief under Article 32. They are saying the right to move to Supreme Court to protect the fundamental right itself is in fundamental right, because Article 32 comes under fundamental rights. So protecting my fundamental right is also a fundamental right to me. However, the Supreme Court has ruled that where relief through High Court is available under 226, the aggrieved party should first move to the High Court. They are saying not. They are saying that not to overcrowd Supreme Court. If the particular relief is available under Article 26, that is under High Court, you can directly go to High Court and not to Supreme Court first. You need to first go to High Court because that particular remedy is already available under Article 226. Huge discounts are going on mega mock test series for TS and AP LAWCET 2024. Enroll now. The link is in description box. You can just ping us on Instagram. This is our Instagram handle. Or else you can just ping us in Telegram.